Copyright History and Music Publishing Revenue Streams Part 2. Let's look at the various copyright acts that have been enacted in the United States. There haven't been that many, and there's been a great distance between each one. The first one after the copyright was included in the Constitution of 1787 was the Copyright Act of 1790. This is the first ever federal copyright law of the USA. There were state laws on copyright before that, but this was the first ever federal law. The term was for 14 years from the time of recording the title thereof, with an option to renew for another 14 years. Not included in that Copyright Act of 1790 was performance and mechanical rights. Performance related to broadcasts and also live performance, and also mechanically reproducing the sound on recordings, because that really didn't happen until later on in the 20th century. The next act was the Copyright Act of 1831. This was the first general revision to the U.S. copyright law. The term at that point was for 28 years with an option to renew for another 14 years. So a total of 42 years, but you had to renew after the first 28-year term. But it did extend from the original term of 14 plus 14 equals 28. From 1831 to 1909, there were no new acts, but in 1909, there was a Copyright Act of 1909, which allowed for the right to perform the work publicly. It was actually first protected in 1889. And also the right to translate the work into other languages, and the right of mechanical reproduction. Now we're dealing with recordings and mechanically reproducing copyrighted music on those recordings. It started first with player piano rolls. That was the first instance of that, and that was literally a mechanical reproduction, as opposed to today, in which everything is pretty much done digitally. So the first term was 28 years from date of first publication, with the option to renew for an additional 28 years within 1 year of expiration of the first term. They had to do it within 1 year of expiration of the first term in order to get it. And some people forgot to register the extension, and so it only lasted for 28 years. But if they did get that within 1 year of the expiration, I mean, if it was less than a year, then it didn't work. If they did that, then they got it for 56 years. And the copyright notice is required in this Copyright Act. Today, it's not required, but it was required at that time. 1909, then the next one is in 1976. Sound recordings are defined as original works of authorship comprising an aggregate of musical, spoken, or other sounds that have been fixed in tangible form. This is very important. Once it's fixed in tangible form, it becomes a copyright. Phonorecords were defined as physical objects in which sounds are fixed. For example, records and tapes. And it also finally addressed television, cable, movies, and records. Publication was defined as distribution to the public, getting the work out to the public. And also in this Copyright Act of 1976, there was a spelling out of the term of fair use, and we'll talk more about that later. Also, the term of copyright was extended from the life of the composer, from their death, plus another 50 years. And if there are more than one composer, it's the last surviving composer. It brought in protection to works not published, but in fixed form, and those without copyright notice. So now, it may not have been published and distributed, but it is a copyright once it is placed in physical form. It can't just be in your mind. It's written down or recorded. Now it's in a fixed, tangible form. And also, it didn't need the copyright notice to become a copyright. And another very important thing is the right of termination. When you create something and you put it in a tangible form, and then you have a publisher take it over, you are in effect transferring the right over to a publisher. Well, you have the right to terminate that transfer 35 years after you granted that that transfer. And this is only in the United States. This just does not exist in other countries with their copyright law. So since also the law went into effect January 1st, 1978. So since this came into effect in January 1st, 1978, 35 years after the effectiveness of that Copyright Act was 2013, and that's a time when some of these rights were being terminated by copyright owners and being recaptured. That's when that first became effective. Then 10 years later, in the Berne Convention Implementation Act of 1988, it's not necessary to have the copyright notice on the work. The work does not need to be registered, but you must register it in order to file an infringement claim. Transfer of the copyright ownership is not required to be registered with the Copyright Office. And PD also refers to public domain songs in the US could have become protected with this Berne Convention Implementation Act. And that's the end of part 2.